Welcome to our deep dive on the L-1B visa and the trap many highly skilled professionals fall into. In this video, we will explain why exceptional technical experience often fails the specialized knowledge standard, and how to build a stronger case. Let's begin with a quick overview, and then move into the details, ensuring smooth transitions between each topic. Here is our agenda. First, we will define what L-1B really tests. Next, we will contrast specialized knowledge with general industry expertise. Then, we will dispel the labor shortage myth. After that, we will address education scrutiny. Subsequently, we will map out evidence that convinces adjudicators. Then, we will show you how to structure your packet effectively. Finally, we will test your understanding with 2 short quizzes. Many employers and employees misunderstand the L-1B visa. They often believe that years of high-stakes technical experience are enough. However, L-1B is intended for intracompany transferees who possess proprietary or uniquely advanced knowledge tied to the petitioning company's systems, products, processes, or methodologies. This is different from general industry expertise obtained through standard licensing or training. With that clarified, let's add an important disclaimer before we proceed. This video provides educational information only and does not constitute legal advice. Immigration matters are fact-specific and complex. You should consult a qualified immigration attorney for advice tailored to your situation. With that disclaimer noted, let's define what specialized knowledge actually means under L-1B. Specialized knowledge under the L-1B category must be either proprietary to the petitioning organization or so advanced that it is not commonly held within the industry. Importantly, even 10 years of elite technical experience does not automatically qualify if the skills are widely taught or standardized, such as through FAA and P licensing or similar trade certifications. The flowchart illustrates the decision points. First, determine if the knowledge is proprietary. If not, it is likely to be considered general industry knowledge and may result in denial. If it is proprietary, assess whether it is uncommon in the industry. If it is not uncommon, the case weakens. If it is uncommon, you must further show it is critical to the company's operations and cannot be quickly taught to a new U.S. hire. That combination builds a stronger case. With the definition clarified, let's compare specialized and general knowledge directly. On the left, specialized knowledge is characterized by proprietary systems or confidential methods that are difficult to transfer without significant company-specific training. It often intersects with internal strategy and architecture and involves company-developed tools or unique engineering methods. On the right, general industry knowledge includes skills obtained through standard licenses or trade schools. These are commonly found in the labor market, rely on widely documented tools and procedures, and, while impressive, are not unique to the company. Now, let's address a pervasive myth about labor shortages. Contrary to popular belief, labor shortages are irrelevant to L-1B adjudication. The visa is not intended to address market scarcity, whether the U.S. needs many mechanics or none at all, the standard for specialized knowledge remains unchanged. The pie chart emphasizes that proprietary or advanced knowledge carries significant weight, while labor shortages carry none. With that myth addressed, let's examine how education plays into modern scrutiny. Although the L-1B statute does not require a university degree, modern adjudication often expects one when the specialized knowledge involves complex systems. For highly skilled tradespeople without degrees, the burden of proof is higher. The petition should demonstrate extensive company-specific training equivalent in rigor to a degree program or clearly tied to the company's proprietary systems. Next, let's convert this into practical evidence you can present. This table outlines evidence categories and examples to include. Proprietary systems can be demonstrated through architecture diagrams, internal manuals, and carefully redacted excerpts of code or procedures. Unique training should be documented with logs showing hours, syllabi, internal certifications, and mentor evaluations to prove intensity beyond standard industry training. Operational criticality can be shown via incident postmortems, uptime metrics, deployment approvals, and change logs that tie the applicant's knowledge to mission-critical operations. Unusual responsibility is best shown with an organizational chart, rosters indicating peer training responsibilities, and evidence of decision rights or sign-off authority. Finally, comparative rarity can be demonstrated with a skills matrix, indicating how few employees possess the same knowledge. With the evidence framework clear, let's detail how to structure your case narrative. To strengthen the case, you should center your narrative on 3 core elements. First, proprietary systems. Connect the applicant's expertise directly to company-owned technology, custom software, unique engineering methods, or confidential operational practices. Second, unusual responsibility. Demonstrate supervisory, mentoring, or strategic decision-making tied to the proprietary knowledge. Third, documentation. Include detailed training records reflecting hundreds of hours of company-specific instruction that exceed standard industry requirements. The sequence diagram shows collaboration among employer, manager, legal, and the authorities. After identifying proprietary systems and roles, collect training and operations records. Legal then compiles and drafts the petition with clear narratives and exhibits. If a request for evidence arrives, provide targeted clarifications to address gaps. Now let's convert this into a practical, step-by-step packet building plan. Follow these steps to assemble your packet. First, start with an executive summary addressing what is proprietary, why it is rare, and why it is critical. Second, include sanitized diagrams and process maps to illustrate the proprietary system. Third, prove depth through training logs that show hours, instructors, and specific competencies. Fourth, demonstrate operational impact using incident reports, change approvals, and production deployment sign-offs. Fifth, show unusual responsibility with organizational charts, mentoring rosters, and authority matrices. Sixth, explicitly contrast the applicant's knowledge with industry norms, explaining why standard licenses or schooling are not sufficient substitutes. Finally, bundle exhibits with clear labels and cross-references so adjudicators can navigate the material efficiently. Before we continue, let's check your understanding with a quick quiz. Quiz time. The question is, does a severe U.S. labor shortage in your field improve your L-1B approval odds? Yes. The options are A. Yes, shortages help because L-1B fills market gaps. B. No, shortages are irrelevant to L-1B's specialized knowledge test. C. Only if the employer shows recruitment efforts. D. Only when combined with a degree requirement. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is no. Shortages are irrelevant to L-1B's specialized knowledge test. L-1B is an intracompany transfer category centered on whether the applicant has proprietary or uniquely advanced knowledge tied to the employer. Labor market conditions do not factor into this evaluation. Now let's proceed to the next quiz to reinforce another key concept. Our second question is, which best exemplifies L-1B specialized knowledge? Option A. Holding an FAA and P license and 10 years of experience. Option B. Mastery of a company's confidential diagnostic platform used nowhere else. Option C. Completion of standard trade school courses with honors. Option D. General familiarity with industry standard machinery. You may pause the video now to consider your answer. We will discuss the answer in the next section of the video. The correct answer is mastery of a company's confidential diagnostic platform used nowhere else. This aligns with the requirement that specialized knowledge be proprietary or exceptionally uncommon in the industry. Standardized licenses, while impressive, usually indicate general industry knowledge rather than company-unique expertise. Next, to situate this in time, let's visualize a high-level L-1B timeline. This timeline depicts the typical L-1B process. First, internal assessment takes 1 to 2 weeks to evaluate whether the knowledge is proprietary and rare. Next, evidence gathering and drafting takes 3 to 6 weeks, during which training logs, system diagrams, and operational artifacts are compiled and narrated. Filing and receipt typically occur within a week. If a request for evidence is issued, the RFE window lasts roughly 8 to 12 weeks, after which a final decision may take 2 to 6 weeks. The diagram also emphasizes that collaboration between the employer, the applicant's manager, and legal counsel is iterative and ongoing. With timing in mind, let's capture the key takeaways. These are the key points. Prove that the knowledge is proprietary or truly uncommon, not merely elite. Document extensive, company-specific training that goes beyond industry norms. Demonstrate unusual responsibility and operational criticality. Do not rely on labor shortages. Focus on the uniqueness of the knowledge. Finally, anticipate education scrutiny and explain the equivalent rigor if the applicant does not hold a traditional degree. To reinforce these points visually, here is a concise decision flow you can reference when evaluating a candidate. This rapid decision flow helps determine readiness. Start by confirming company proprietary knowledge. If not, consider alternatives. If yes, determine whether the knowledge is uncommon within the industry. If not, the case is likely unsuitable. If it is uncommon, assess whether it is hard to teach quickly. If it is not, strengthen the training evidence to demonstrate difficulty in transfer. Next, evaluate whether the knowledge is operationally critical and paired with unusual responsibility. If that is weak, supplement with concrete evidence. If strong, the candidate is more likely to succeed under L-1B. Finally, let's summarize and wrap up. To summarize, L-1B approval hinges on demonstrating proprietary or truly uncommon knowledge with specific, credible evidence. Show depth with detailed training logs, unique tools, and confidential methods. Demonstrate impact through critical operations involvement and unusual responsibility. Plan for scrutiny by addressing degree equivalence and providing detailed documentation. As a final note, always coordinate with experienced counsel to tailor evidence to your facts. Thank you for watching. If you found this valuable, please like, share, and subscribe. Share your toughest L-1B questions or experiences in the comments. We appreciate your engagement and look forward to helping you navigate complex immigration topics.